Hi, this is Ty Hyderali. I'm a plaintiff's lawyer who concentrates in employment law. We have offices in New Jersey and New York. I want to discuss with you the topic of arbitration. So in New Jersey, we have the New Jersey law against discrimination, which allows someone access to the courts to pursue claims of discrimination, retaliation, sexual harassment. And in March of 2019, our Governor Murphy, signed a bill into law to put an end to the forced arbitration of employment cases. Good news is seemingly so. Unfortunately, we have something called the Federal Arbitration Act, which says that arbitration is permitted. And so when these cases under Section 12.7, which amended the law against discrimination, came to play, unfortunately, they didn't do too well because the courts stated that, well, because of the FAA and something called the Supremacy Clause and preemption, etc., you cannot pursue discrimination. You cannot compel discrimination claims to go to the courts when you have an arbitration agreement in many circumstances. All right. So that's the backdrop. What happens next is President Biden very recently signed a bill that amends the FAA. It's called the EFFA, the Ending of Forced Arbitration of Sexual Harassment and Sexual Assault Cases. So that came down in November of this year, very recently, actually. Great statute. So that's the backdrop. I'm sorry, that came down in March of 2022. That was the backdrop for a case called Zuluaga versus Altus, United States, which actually came up to the appellate court in New Jersey in November of this year. All right, so what's that case? Laura Altus claimed that she was subjected to sexual harassment at the workplace and constructive discharge and wanted to sue Altus in the courts. Laura had signed an arbitration agreement at the trial court level. The company moved to dismiss the claims and was successful. This went up to the appellate court. And the argument was, well, wait a second, we understand the FAA exists. However, this is a sexual harassment case. There's something called the EFFA. So Laura should not be compelled to arbitrate her claims of sexual harassment. At the appellate court level, arguments were successful. Good news for everyone. Unfortunately, because her claims of sexual harassment arose before the passage of the EFFA, the court said, unfortunately, Laura, for your situation, we're not going to void or vitiate the arbitration agreement because your claims arose prior to the enactment of the amendment to the FAA. However, going forward, what appears to be the case is good news for all who have claims of sexual harassment under the New Jersey LAD, that even if you have an arbitration agreement, you may not be forced to, the company may not be successful in forcing you to compel your claims of sexual harassment. More to come. President Biden and Vice President Kamala Harris have stated that they intend to further broaden the exceptions to forced arbitration in the employment sphere. This is Ty Hyderali. Be safe and be well.